The news continues to break 2 weeks now since the FBI searched Donald Trump's home at Mar-a-Lago. With every new revelation, every day, the facts just keep getting worse for the ex-president. You don't have to take my word for it. Trump's Republican allies have made that very clear all on their own. In their attempts to defend him, they've been running around painting hypothetical thought experiments about how bad the situation could be. Now, sure, the ex-president took a bunch of classified documents from the White House, but how classified are they really?
You can say nuclear weapons, but there are things that are highly, highly classified. There's things that are not extremely classified, but are nonetheless classified. It would be very, very narrow of anything that just has the umbrella of nuclear weapons in it that would rise to the level of an immediate national security threat.
That was a top-ranking Republican in the House Intelligence Committee, Congressman Mike Turner of Ohio, saying that it might not be a big deal that Trump had nuclear secrets sitting around Mar-a-Lago. Now, that was his argument in the first few days after the search. He's since tried out a bunch of other defenses, including recently claiming the ex-president just needed the classified documents so he could sit down and write his memoir.
What use could a former president have for classified or top secret information once he's left office? Why bring it home with him to Florida?
Well, I don't know. I mean, you'd have to ask him, but certainly we all know that every former president has access to their documents. It's how they write their memoirs. They don't have, great recall of everything that's occurred in their administration.
I mean, first of all, access to their documents is key here, right? They're not retaining it. But also, it's kind of fun to visualize Trump burning the midnight oil, sitting at his desk at Mar-a-Lago, top secret documents splayed across the room, feverishly writing his memoir. Mike Turner is not the only Republican who's tried this odd defense of talking about all the hypothetical worst documents Trump could have taken to Mar-a-Lago. Congressman Chris Stewart of Utah, also a member of the Intelligence Committee, painted this worst-case scenario in an interview with Politico earlier this month. Quote, I mean, if he had actual special access programs, some of the government's most highly classified material, do you know how extraordinarily sensitive that is? That's very, very sensitive. If that were actually at his residence, that would be a problem, but we just don't know that. So let's find out. Congressman Mike McCall of Texas, a top Republican on the Foreign Affairs Committee, added, quote, when you get to compartmentalized classified spaces, it gets more spurious. Well, guess what, Congressman? That's exactly the kind of information the FBI recovered at Mar-a-Lago 2 weeks ago. We now know that thanks to this letter, written May 10th from the National Archivist to Donald Trump's lawyer, that recovery of the FBI wasn't the first such recovery of those kinds of documents. This letter was first made public by conservative journalist, Trump loyalist John Solomon. And in the letter, the archivist refers to the first 15 boxes of records they recovered from Mar-a-Lago in January. She writes, quote, in its initial review of materials within those boxes, the National Archives identified items marked as classified national security information up to the level of top secret and including, Chris Stewart, Michael McFaul, sensitive compartmented information and special access program materials. Precisely the type of extremely secret material Donald Trump's backers called, quote, more serious and a problem. In fact, this letter shows that basically everyone in the federal government who was read on this and was aware of these documents and how top secret they were ringing the alarm bell. The archivist goes on to quote a previous letter the Department of Justice's National Security Division sent Trump's lawyer in late April, laying out the, quote, important national security interests in the FBI and others in the intelligence community getting access to these materials. They also reveal that in just, again, those first 15 boxes they had to kind of pry out of Donald Trump, they didn't get till January, they found over 100 documents with classification markings comprising more than 700 pages. That's the first batch turned over. DOJ continues, quote, access to the materials is not only necessary for purposes of our ongoing criminal investigation, but the executive branch must also conduct an assessment of the potential damage resulting from the apparent manner in which these materials were stored and transported and take any necessary remedial steps. That's a representation of the overall tone of this letter, which is quite serious the whole way through, which makes sense considering where it falls in the timeline of the U.S. federal government's many efforts to get these documents back from Donald Trump. The National Archives first contacted Trump back in May of 2021, more than a year ago, about the missing documents. They tried again that fall, before initially retrieving 15 boxes of records from Mar-a-Lago in January this year. Then they get all those boxes, right? They're like, okay, here's a bunch of boxes. Wait, what? They go through them, we now know, and find they contain 700 pages of classified documents. That freaks them all out. The National Archives refers the matter to the Department of Justice the following month. They sent Trump's team a letter in April informing them they would be giving the FBI access to the documents recovered in January as soon as the following week because, well, they've got to do an assessment of the possible damage here. This letter, the one we're now seeing for the first time, came on May 10th. We know that Donald Trump received a subpoena for the documents later that month, right? So they sent him a letter being like, dude, this is bad. This is not good. We're letting the FBI have these. We need to get all these documents. Then after that, there's a subpoena, right, where a court says, you have to turn over the documents. Then federal officials visited Mar-a-Lago in June. This is not the search warrant. This is they come and they took more documents, which he's still holding on to, and that's before the FBI finally goes the final mile, executing the search warrant 2 weeks ago. Now, since the very beginning of the story, there's never really been a question about some of the basic facts. For instance, whether Donald Trump took documents that were not his to take. We know unequivocally they weren't his to take. He should not have removed these documents from the White House and brought them to Mar-a-Lago. They belong, under law, to the National Archives. So the next question was, well, was there classified material among these documents? And again, that's not really up for debate. The answer to that is a clear yes. In fact, in defending Trump, many of Trump's spokespeople seem to have essentially conceded that point. So then the next question, the one we heard Trump's allies ask was, well, how classified are they? Because it's true, a lot of stuff is classified in the government and a lot of stuff is overclassified, frankly. So are we talking about the highest levels of classification or, just like more pedestrian classification? Well, we now know the answer to that they were among the most highly classified material. The kinds of material that Trump's Republican defenders in Congress identified before it was revealed as the really problematic stuff. So then the final question, the biggest one, the one that matters the most, I think, at this point legally is, was Trump's action willful or was it sloppy? And I'll say, at first, it wasn't that clear. I was agnostic about it. I didn't know. I mean, you never expect the best of Donald Trump. But also, clearly, this is not the most careful person in the world. Like, who's got the best document retention practices? So it seemed to me there could be a plausible story of sloppiness. But the barrage of facts we've gotten since the search in Mar-a-Lago has shown how almost obsessively, single-mindedly willful this was. As the New York Times reports today, quote, 2 former White House officials who have been designated as among Trump's representatives with the archives tried to facilitate the documents' return. But the ex-president resisted those calls, describing the boxes of documents as, quote, mine. That's according to 3 advisors familiar with his comments, which, by the way, side note, Donald Trump, looks like you got some folks talking out of turn in that operation there. Now, according to the Times, Trump, and this is really, I can't believe this, Trump also went through the boxes himself in 2021 before turning them over. Now, to keep in mind what boxes we're talking about, remember, that was just the 15 boxes the National Archives took in January containing the 700 pages of classified material, which we now know was nowhere near everything. The Times doesn't explicitly say this, but just to underline what they appear to be implying, it looks like maybe he went through and just kept some of it and turned over others. It goes on. The Mar-a-Lago surveillance footage that DOJ subpoenaed in June, quote, raised concerns for investigators, again, revealing people moving boxes in and out, and in some cases appearing to change the containers some documents were held in. Okay, what are we doing here? Nearly impossible at this point on a good faith reading of the available evidence, which maybe some of it's wrong, but a lot of it's uncontested. Impossible not to say this was not willful, or more plainly, this was willful. He took it. This is a guy who just took a bunch of top secret documents home from the White House because he wanted them. For what motivation? I don't know. But that's not even that germane because he decided they were his, and he tried to hide them and to keep them after being repeatedly instructed to return them. Andrew Weissman spent years working in the Department of Justice, most recently served as lead prosecutor in Robert Mueller's special counsel investigation. He now teaches criminal and national security law at New York University, and he joins me now. Andrew, first let's just talk about the letter and what the letter adds, the letter that we now have from the National Archives, adds to the full picture of the timeline here and the efforts that the various parts of the federal government went to try to retrieve all of the classified documents that were supposed to be turned over to them.
Yeah, so the letter is quite odd because it was disclosed first by John Solomon, who works for the former president, and is a designee by the former president to the presidential records that would be kept by the National Archives. But the letter is incredibly damning to the former president. It really is odd as to why he released it. And the way it's damning is exactly as you say, Chris, which is the time period between when the former president left office and today is the most damning evidence, because there's one version of the defense, which is, hey, it was chaotic when I was leaving and I didn't really know what was in the boxes and I didn't intend to take them. And as soon as it was called to my attention, I returned everything. That's one story. The problem is that this letter, among many other things that you pointed out, makes that not a possible factual defense, because over and over again, the Department of Justice was trying everything and bending over backwards, as was the National Archives, to do everything short of a subpoena and short of a search. That letter, actually, one of the more shocking things is, even though there's a clear national security imperative to do an assessment of what happened to those documents, that letter is on behalf of Donald Trump saying, please delay that. We do not want these documents shared with the intelligence community, the FBI, the CIA, the NSA, to do that assessment. I mean, talk about unpatriotic. But in terms of the criminal case that's going on, it makes the issue of was this an accident or was it intentional, I think, beyond a reasonable doubt.
Yeah, so I want to read from the Espionage Act, and I've said this before, I think is in many ways a bad law. It has certainly been used, I think, in incredibly questionable ways in the past. It's passed during the Red Scare in Wilson administration. But just to be clear on what it says here, right? I'm not going to read the whole thing, but it says basically whoever lawfully having possession of, access to, control over, being entrusted with, and it lists all these things, right? That you could, notes or appliances, blueprints, maps, right? That have national defense information. And willfully retains the same, and then get this, and fails to deliver it on demand to the officer or employee of the United States entitled to receive it. Like, they add an extra bar in the statutory language that says this can't be an accident. It also has to be the case that if they come calling because you have it, you get a chance to turn it over and basically not meet the criteria for willful retention. But if you don't turn it over, then maybe you're in that ballpark, and it almost matches, like, uncannily what the facts are here.
Yeah, we'll also add in that you have the obstruction charge, the 1519 charge, because not only did he not turn over everything, but the government, I think, quite plausibly contends, based on all of the reporting, that he partially turned over documents and deliberately retained the other ones. The portion of the New York Times story that you read, that several people informed the New York Times that the president personally looked through the documents, meaning he decided what would be turned over and what would not be turned over, is exactly why you have a 1519 obstruction charge. I should also say, Chris, there's some very simple charges here. It is simply theft of government property, which is 18 U.S.C. 641. That is a really simple crime, and that is clearly satisfied here. And the president, frankly, has not only not denied that, but his filings, whether it's this letter or his more recent filing in Florida, are frankly in a confession to that crime of just taking government property.
The final question I want to ask you is about executive privilege. I've been somewhat frustrated in a lot of the proceedings here, from Pat Cipollone to the president in the letter that's referenced here. There doesn't seem to actually be a coherent theory of what it is. It appears willy-nilly from Trump or his lawyers as this kind of like magic cape to throw over things. I don't even understand what the claim here is about the privilege they're describing when the lawyer attempts to say, well, prophylactically, we're just claiming privilege over this. You can't show it to the FBI.
Yeah, so you're right to be confused because the claim doesn't have any merit. So executive privilege is a privilege where the president says, I'm entitled to hear from my closest advisors, and those communications are things that should not be made public. That is not applicable here for a whole host of reasons, one of which is that this is not a defense to the relief that Donald Trump is requesting. Donald Trump says, executive privilege, give the documents back to me. No, if it's executive privilege, it means the documents are government documents that need to go to the National Archives. So the relief would not be returning them to Donald Trump. It would be giving them to the National Archives. Second, it's the current president who has the privilege.
Right? Like, if it's executive, if it's a privileged document, right, then it is work product that, it's vital work product. It's the type of thing that belongs in the archives, not in the Mar-a-Lago basement.
Exactly. And the other is, when I was in the special counsel, we dealt with getting documents from the Trump White House. And we were in the executive branch. We were at the Department of Justice. We reported to the Attorney General, who reported to the president. So these documents were going from the White House to the Department of Justice. That's within the executive branch. Right. Executive privilege does not apply to documents going within the executive branch itself. Right. It's only going outside of it.
Right.
So that doesn't work in this situation since the search was done by the executive branch.
Well, thank you. Nothing I love more than someone telling me I'm right, Andrew Weissman. Thank you very much.